I'm Professor Delcianna Winders, Director of the Animal Law and Policy Institute at Vermont Law School, which trains future animal advocacy leaders and centers animals in the fight for environmental protection. I started studying animal law when I was about 14 years old, long before I ever went to law school, after Olivia and Dodger, two pigs who I had bottle fed and raised as my companions, first in my bedroom, then in our backyard, were unexpectedly slaughtered. This sent me on a rapid learning journey in the public library because ready access to the internet was not yet available, where I devoured everything I could find about animal protection, about factory farming, and about how our laws do and do not protect animals. Eventually, I went to law school specifically in order to practice animal law, which I have been doing now for 15 years. I started out my animal law career at an award-winning public interest firm. I've also worked as the director of legal campaigns for Farm Sanctuary, a leading farmed animal protection organization. And for many years, I was vice president and deputy general counsel for captive animal law enforcement at the PETA Foundation. In addition to my practice, I have taught animal law for about a decade. I've held academic positions at numerous law schools, including Lewis and Clark, Harvard, and Pace. One of the things I learned very early is that the Animal Welfare Act, our nation's most significant animal protection law, is inadequate and is failing to fulfill its purposes and is not protecting animals in the way Congress intended it to. These failings have become a central theme of my practice and my scholarship. Through litigation, I have helped rehome many animals. My team at the PETA Foundation rescued well over 100 animals from a wide variety of shoddy Animal Welfare Act licensed facilities where they were suffering. This includes many bears, dozens of big cats, numerous solitary chimpanzees, and Nosy, an elephant who I was able to personally accompany on her journey to the Elephant Sanctuary, one of the only accredited elephant sanctuaries in the United States, after she was held for decades without the company of a single other elephant, without veterinary care for myriad medical conditions, chained so tightly she could barely move for many years while the USDA did nothing to help her, despite clear violations of the Animal Welfare Act. Helping these individual animals has been critically important to building my own resilience and knowing that I can make a difference, and has been, of course, important to these animals who languished for many years and are now thriving in sanctuary. But it's not enough. We also need to fundamentally change the law and the way that it's implemented so that other animals don't continue to suffer. In order to try to facilitate such changes, I've published numerous articles in top-ranked law journals recommending policy solutions for the myriad failings of the Animal Welfare Act. I've also sued the U.S. Department of Agriculture for failing to do its job under the Animal Welfare Act about a dozen times, usually as counsel on behalf of organizations and sometimes individuals, but occasionally also as a plaintiff in my own individual capacity. I've also drafted legislation to help address these issues, including helping with a bill that is currently pending in Congress. Today, I'm going to give you an overview of the Animal Welfare Act. I'm going to start with a discussion of the history of the Act and some really key early developments that continue to inform how the law plays out today. I'm going to talk about which animals the Animal Welfare Act covers, and importantly, which animals it excludes. I'm going to talk about how the Animal Welfare Act works for those animals who are covered, and how it is, and importantly, is not enforced. Finally, I'm going to talk about the important role of transparency, and I'm going to make some recommendations for things that we and you specifically can do to help remedy longstanding problems with the Animal Welfare Act. As Professor Paul Locke discusses in his Animal Law Fundamentals presentation on laboratory animal law in the United States, the Animal Welfare Act was first enacted in 1966, following a Sports Illustrated story about a dog named Pepper who had gone missing from her home only to die on an experimentation table. And then a few months later, a feature story in Life magazine referring to concentration camps for dogs with full-page photos of the horrific conditions at compounds where dogs were being held before being sold off to research facilities. Life magazine and Congress received more mail about these concerns than about the civil rights movement and the Vietnam War combined. And remember, this is in 1966. The initial stated purpose of the Animal Welfare Act was focused on this concern about pet napping. It was to protect dog and cat owners from pet theft and to prevent the sale and use of stolen cats and dogs to laboratories. That is, the Animal Welfare Act was originally focused on protecting human property interests, a recurring theme in animal law. But there was another stated purpose, and that was ensuring that certain animals intended for use in research receive humane care and treatment. There's some key elements of the original Animal Welfare Act that are really important to understand because they continue to inform how the law is and is not implemented today. The first, and a very important one, is the role of the U.S. Department of Agriculture. The National Institutes of Health is the agency in the federal government that funds and conducts animal experimentation on the largest scale. The NIH long opposed efforts to regulate the use of animals in experimentation and urged self-regulation rather than government oversight. When it became clear that because of public outcry and the media coverage that I just discussed, that the Animal Welfare Act was finally going to be enacted, the NIH changed its tune and pushed to be responsible for implementing that law. Industry also lobbied very hard for that responsibility to be given to the NIH. Congress settled on the U.S. Department of Agriculture, which was responsible for implementing the Humane Methods of Slaughter Act and had relationships with state veterinarians. The USDA, however, was not interested in taking on this new responsibility. Then Secretary of Agriculture Orville L. Freeman told Congress, cats and dogs are not areas as to which this department has expertise, that the USDA's animal expertise was limited to livestock and poultry, and that the Animal Welfare Act should, quote, be administered by a federal agency more directly concerned. Despite the USDA's vigorous efforts to avoid this responsibility, Congress foisted Animal Welfare Act enforcement on the USDA. The USDA's disinterest has persisted. When the Animal Welfare Act was amended a few years after it was first enacted to be expanded and cover more types of animals and uses of animals, the USDA reprised its opposition. USDA Associate Administrator Dr. Francis J. Mulhern told Congress again that the NIH, not the USDA, should be responsible for this statute. Another piece of the Animal Welfare Act's history that is very important to understand and that carries forward to this day is the way in which animal experimenters are treated differently from other types of regulated entities. They are given a much lighter touch. Suppliers of animals for research in the original Animal Welfare Act had to get licensed, and they could not get a license unless they showed that they were complying with minimum welfare standards. If they failed to comply with those standards, the USDA could take that license away. Could also enforce criminal penalties against them. It could confiscate animals. Experimenters, on the other hand, have never had to be licensed under the Animal Welfare Act. From the beginning, they have simply had to register, meaning effectively telling the USDA we're going to do experiments on animals. There are no conditions on that registration. There is no ability to remove that registration or to remove the ability to conduct experiments on animals. No matter how badly an animal experimenter violates the law, the USDA cannot suspend their operations. And the USDA can only confiscate animals from experimenters if the experimenter happens to be done using the animals for experimentation. That means no matter how badly an animal is suffering, no matter how clear it is that the law is being violated, an experimenter can finish out their experimentation. Research facilities are also not subject to criminal penalties under the law. They can only be fined. And this is significant because the USDA, as I'll discuss in a bit, has a history of making penalties so low that they're treated as a cost of doing business. Another important question that goes to the very beginning of the Animal Welfare Act is which animals are covered. This is an important question in animal law in general, but it's especially important in the context of the Animal Welfare Act, and it's especially convoluted under the Animal Welfare Act. So the law originally focused on dogs and cats, and it provided oversight of dealers and research facilities that used dogs and cats. However, once that oversight was triggered, it also extended to guinea pigs, hamsters, rabbits, and primates. So if a facility used dogs and cats and also used these other categories of animals, all of those uses would be regulated. But if they only used these other categories of animals and did not use any dogs or cats, there was no federal oversight. This has since been expanded over the years. So today, additional facilities, additional types of animal use, and additional categories of animals are covered. That includes still research facilities and the dealers that supply them, animal exhibitors, things like roadside zoos, traveling circuses, traditional zoos. It also includes suppliers for exhibition and for the wholesale pet trade, and those who transport animals in commerce. The purposes of the Animal Welfare Act have also shifted over the years. Originally, the Animal Welfare Act focused on protecting animal owners from theft. That is still a stated purpose in the Animal Welfare Act, but that is now a tertiary purpose. The primary stated purpose is to ensure that animals intended for use in research or exhibition or for use as pets are provided humane care and treatment. So the primary focus has shifted to the animals and animal welfare rather than protecting human property interests. However, there are still some very significant categories of animals who are excluded from the Animal Welfare Act. This includes the billions of animals we raise and kill for food every year in the United States. This use of animals is not covered by the Animal Welfare Act, but to be doubly sure that animal agriculture would not be touched by the Animal Welfare Act, Congress also explicitly excluded farmed animals from the very definition of animal. As a result, there is no federal law that governs the on-farm treatment of animals used for food. Cold-blooded animals also have no protection under the Animal Welfare Act. This includes fish, amphibians, reptiles, and others, even when they're used for purposes like research, exhibition, and the pet trade that would otherwise be covered. And even though abundant scientific evidence makes clear that these animals are sentient and have complex welfare needs. In addition, rats of the genus Rattus and mice of the genus Mus, which are the two genuses most commonly used for experimentation, and birds are excluded from the Animal Welfare Act when used for research. This is due to industry pressure. They are still covered, at least in theory, when they're used for exhibition or the pet trade, but not when used for research. Rats and mice of other genuses, such as deer mice, are still covered. Horses have the opposite situation. Horses are covered only when they're used for research. So when horses are used for the pet trade or for exhibition, such as racing, they are not covered. So there are some very significant concerning exclusions from the Animal Welfare Act, given that it is our primary federal animal protection law. Nevertheless, it does cover more than 2 million animals at more than 11,000 locations across the United States. And the way that it is applied to these animals is through a licensing and inspection regime. Animal exhibitors, breeders, and dealers need to demonstrate compliance with minimum welfare standards before they can get licensed. Notably, the USDA historically has not required a demonstration of compliance for renewal of a license. That is changing, and it has posed some problems. But at least before a first license is issued, a demonstration of compliance has always been required. That is not the case for research facilities or for commercial transporters. They are registered. They do not need to demonstrate compliance. So for the animals who are supposed to be covered by the Animal Welfare Act, what does that look like? How does it work on the ground? The Animal Welfare Act is implemented through a licensing and inspection regime. So animal exhibitors, breeders, and dealers have to be licensed by the USDA. And before they can get a license, they must demonstrate compliance with minimum welfare standards. Historically, the U.S. Department of Agriculture has not required compliance for renewing a license. And it has, in its own words, automatically renewed licenses. It has rubber-stamped license renewal applications, no matter how badly an entity is violating the law and harming animals. A series of lawsuits brought by myself on behalf of PETA and other organizations, and by the Animal Legal Defense Fund, and a law review article that I published in the Florida State University Law Review have challenged this automatic renewal. And after years of advocacy, that is in the process of changing. So the USDA is implementing a requirement that renewal be conditioned on compliance with minimum welfare standards, in addition to the conditioning of an initial license issuance. Research facilities, as I've discussed, and commercial transporters are registered rather than licensed, and so they have no requirement of demonstrating compliance. But whether or not you're licensed or registered, all Animal Welfare Act regulated entities are subject to routine inspections by the U.S. Department of Agriculture. These inspections are supposed to be unannounced. As I've mentioned, the Animal Welfare Act applies to more than 2 million animals at more than 11,000 locations across the United States. To conduct all of these inspections, the USDA employs a mere 100 inspectors. The law requires that research facilities be inspected at least once a year, although it has recently come to light that these inspections are not always comprehensive and may only look at one component of the research facility's activities. Other types of entities have no specified frequency for inspection. As a result, breeders, dealers, and exhibitors can go years without being inspected, and do go years without being inspected. When these facilities are inspected, the USDA inspectors are assessing for compliance with minimum regulatory welfare standards. And these standards are published in what is called the Blue Book that contains all of the requirements. Generally speaking, these are performance standards. They're not engineering standards. They don't specify specific things that facilities have to do or cannot do. They require them to have plans to meet goals such as enrichment for primates. These plans are not submitted to the U.S. Department of Agriculture. They simply need to be maintained on site. And as a result, they are not available to the public, even through the Freedom of Information Act. There are specific regulatory welfare requirements for a small handful of types of animals: dogs, cats, guinea pigs, hamsters, rabbits, primates, and marine mammals. All other categories of animals who are covered by the Animal Welfare Act, everything from aardvarks to bats to bears, lions, tigers, elephants, zebras, all of those animals and many more are covered by what are called generic standards. Very broad, generic requirements that are not accounting for these animals' species-specific needs. To give you one example, the requirement for space for all of these animals and more is that enclosures be constructed and maintained to provide sufficient space to allow each animal to make normal postural and social adjustments with adequate freedom of movement. If you're scratching your head about what that means, you are certainly not alone. Regulated entities have a hard time understanding what this means. The USDA inspectors who are supposed to be enforcing this requirement also have a hard time. To give you just one example, I've seen agency records where an inspector notes that a bear in a very small enclosure was pacing incessantly back and forth, a sign of poor welfare and of inadequate space, but that because the law was so vague and so general, the inspector did not feel like she could even cite the facility for violating the requirement. For some animals, there are meaningful requirements. For primates, there needs to be attention to their psychological well-being, their deep social needs. There needs to be enrichment. For dogs, there needs to be exercise, which the USDA for many years opposed requiring, claiming that there was no scientific evidence that dogs needed exercise and couldn't simply be kept in cages 24 hours a day, 7 days a week. For marine mammals, it requires attention to their social needs. For most animals, it doesn't even require this much. It requires the basics: food, water, shelter, and even there, it's quite vague on what specifically is required. Nevertheless, it is something, and when there are violations of these bare minimum standards, because they're so minimal, it's important that facilities be held accountable. What I'm going to talk about next is what happens when violations of these minimum standards are documented, what the USDA does about it, and, unfortunately, what they often do not do about it. So what happens when someone is caught violating even these minimal welfare requirements? How does the USDA enforce the Animal Welfare Act? Under the law, the USDA has a range of penalties at its disposal, much more than many other agencies and under many other statutes. For licensees, criminal penalties, both prison sentences and monetary criminal fines, are available. For all types of entities, civil fines are available, and they are regularly adjusted for inflation. The current amount of a civil fine is $12,771 per day, per animal, per violation. That can add up pretty quickly. The USDA also has the ability to temporarily suspend, to terminate, and to permanently revoke Animal Welfare Act licenses. It can also seek cease and desist orders. It can confiscate animals who are suffering due to violations of the Animal Welfare Act. And it can seek injunctions. The USDA very rarely uses any of these tools. As of today, the USDA has published 55 enforcement actions this year, 2022. 52 of those, or 94.5%, are warnings. The others, there are 2 complaints initiating administrative lawsuits, and there is 1 settlement. So warnings, by far, are the primary so-called enforcement mechanism for the Animal Welfare Act, even though they are not one of the enforcement avenues provided by statute. So what is a warning? A warning is a letter from the USDA telling a regulated entity, we have reason to believe you violated the law in these ways, on these dates, and if you keep doing it, we might do something more serious. To give you just one example, the Barry R. Kirshner Wildlife Foundation, which is a nice sounding name for a bad roadside zoo in Oroville, California, with a long history of violations of the Animal Welfare Act, recently allowed a leopard, an apex predator, to attack a senior volunteer and to get loose. The USDA slapped it with a warning, nothing more. Another example, and there are so many, so I'll just give you one more. Levi Stoltzfus of Allenwood, Pennsylvania, one of many, many guinea pig breeders in Pennsylvania, recently was caught with 4 guinea pigs who were suffering from health conditions that he hadn't even noticed, let alone sought veterinary care for. One of the guinea pigs was lame. Her back legs were not working at all, and she had sores on those legs from dragging them. The 3 other guinea pigs had large masses on their chins, which were potentially painful and potentially signs of very serious issues, but they'd not gotten any veterinary care. He was given a warning. Because warnings are so heavily relied on by the USDA in enforcing the Animal Welfare Act, and because the USDA claims that they're a way of swiftly bringing violators into compliance with the law, I undertook a detailed analysis of recidivism after warnings were received. I was looking at the efficacy of warnings as a deterrent. And that analysis was published in the Ohio State Law Journal. What I found, perhaps not surprisingly, is that after a warning is received, it is more likely that someone will continue to violate the law than it is that they will come into compliance. And that nearly half continue to violate the same regulatory subsection, the same specific thing for which they had received a warning. For example, a number of dog breeders who were warned for failing to provide adequate veterinary care to dogs continued inspection after inspection after inspection to fail to provide adequate veterinary care to dogs. What's more, most of these ongoing violators did not face threatened subsequent enforcement action by the USDA. If they did, it most likely took the form of another warning or even a third warning. And they continued to violate even after receiving these second and third warnings. As the U.S. Supreme Court has observed, a threat has no deterrent value unless it is credible that it will be carried out. The USDA's use of warnings brings to mind a skit by Robin Williams where he questions how British police officers have any authority given that they don't have firearms, and posits that they must simply say stop or I'll say stop again. Year after year, decade after decade, across presidential administrations, warnings have been the primary tool that the USDA has relied on to enforce the Animal Welfare Act. The vast majority of so-called enforcement actions are consistently warnings. In many years, this exceeds 80, even 90% of all actions taken under the Animal Welfare Act. So warnings are the primary enforcement tool used by the U.S. Department of Agriculture. No other tools are used with nearly as much frequency. The next most frequently used is settlement agreements. Basically, an agreement to pay a discounted penalty to avoid further enforcement action. As I noted, adjusted for inflation, the Animal Welfare Act provides for penalties of nearly $13,000 per day, per animal, per violation. Unfortunately, the U.S. Department of Agriculture routinely and consistently discounts this to just pennies on the dollar, even in cases where there is severe animal suffering and even animal death. The USDA's own Office of Inspector General has repeatedly condemned these discounted penalties and said that they result in, quote, ineffective enforcement of the Animal Welfare Act and cause regulated entities to treat fines as a, quote, cost of doing business and fail to deter violations. To give you one example, a petting zoo at Anderson and Girls Orchards in Stanton, Michigan, which holds nearly 200 Animal Welfare Act regulated animals, recently faced well over $100,000 in potential fines for a long series of violations, including a newborn marmoset who died without receiving any veterinary care, failure to provide veterinary care for an underweight squirrel monkey named Mojo, who had thinning hair and was constantly scratching himself, and about a dozen animals who simply went missing because of improper enclosures. Despite the fact that they could have been assessed well over $100,000, this petting zoo was fined just $3,875. This is not an extreme example. This is run-of-the-mill. This is standard. In rare instances, the U.S. Department of Agriculture will file a formal complaint initiating an administrative lawsuit. There are just a small handful of these each year, and there are very long delays in pursuing these lawsuits because the USDA insists on providing outmoded, extreme procedural protections that are not required by due process, are not required by the Animal Welfare Act, are not required by any other law. So while many other agencies and the USDA itself in other contexts have informal hearing procedures to resolve violations of many, many laws, in the context of the Animal Welfare Act, the USDA insists on providing full trial-type, on-the-record hearings for any alleged complaint. Decades ago, the USDA's Office of Inspector General raised concerns about the delays that these procedures were causing and the fact that animals were suffering in contravention of the Animal Welfare Act because of these delays. The only thing that has changed since then is that the delays have gotten longer. The animals are suffering for longer. The USDA's own Chief Office of Administrative Law Judges has also noted that these procedural rules are outdated, long overdue for updating. But the USDA has made no move to update them. Confiscation is also available, but very rarely utilized. In the rare instance where the USDA confiscates animals, it is often, almost always, too late. It is after other animals have died and those who've survived have been suffering for months or even years. The USDA's ability to seek injunctive relief to help animals also is very rarely utilized. Although the Animal Welfare Act has been on the books for more than half a century, the USDA just used this tool for the very first time against Jeff Lowe of Tiger King infamy. Hopefully, this is a sign that the agency is going to start making use of this important way to help animals, but there's been no indication of other uses of the injunctive relief avenue. As Abraham Lincoln is said to have observed, laws without enforcement are just as good as advice. These violations are typically not addressed. These enforcement failures are then compounded by the fact that the USDA automatically renews licenses of violators. The licensing process should be a check to ensure that even if you don't face enforcement, at least you cannot continue to operate and get a new license year in and year out. But unfortunately, that has not been the case. Given the U.S. Department of Agriculture's abysmal enforcement of the Animal Welfare Act across administrations, there are a number of other aspects of enforcement that it's important to understand. The first is that the Animal Welfare Act does not have a citizen suit provision. A citizen suit provision allows private individuals and nonprofit organizations, any private citizen really, to go into court and sue to enforce a law where the government is not doing so. This is a well-recognized supplement to government enforcement. It is prevalent particularly in our federal environmental laws, such as the Clean Water Act and the Endangered Species Act. But it is not available under the Animal Welfare Act, where it is very needed. As a result, the USDA has a monopoly on enforcement. The other thing that it's important to understand is that the Animal Welfare Act does not preempt state or local laws. The Animal Welfare Act explicitly gives state and local governments the ability not just to regulate the same entities that are regulated by the USDA under the law, but to impose greater requirements, to impose more meaningful restrictions. Unfortunately, state and local governments often will defer to the USDA and will say, when confronted with a violator in their jurisdiction, whether that's a roadside zoo, a puppy mill, or something else, this is a job for the USDA. They have expertise. They have resources. We aren't going to step in here. But there are exceptions to that. Nosy the elephant, who I mentioned at the beginning, was seized by local law enforcement in Alabama, who stepped in where the USDA had failed for decades. We're also seeing changes as states and especially local governments start to enact laws to prohibit some of the most egregious abuses that have been allowed by the USDA under the Animal Welfare Act. Many local governments and now a number of states have banned traveling wild animal acts because of the recognition that these animals are forced to perform through physical abuse and kept cramped in tiny quarters, unable to engage in their natural roaming behaviors. Similarly, many local jurisdictions and a growing number of states have banned the retail sales of animals like cats and dogs out of a recognition of the unacceptable conditions animals used in this industry are kept in that the USDA allows. So there are potential avenues available and they're starting to be used, but they need to be utilized much more frequently in order to protect animals. I'm next going to talk about the critically important role that transparency plays in the context of the Animal Welfare Act in light of the U.S. Department of Agriculture's chronic enforcement failures. I'm going to give a broad overview of this issue. If you'd like to do a deeper dive, I published a piece on it in the Denver Law Review that goes into much more detail. Information is said to be the currency of democracy. U.S. Supreme Court Justice Louis Brandeis famously said, "Publicity is justly commended as a remedy for social and industrial diseases. Sunlight is said to be the best of disinfectants, electric light the most efficient policeman." This is especially true in the context of the Animal Welfare Act for two intertwined reasons. First, the need to monitor the USDA's fulfillment of congressional mandates or failure to fulfill congressional mandates. And two, to be able to step in to help animals who have been failed by the U.S. Department of Agriculture. The Freedom of Information Act, or FOIA, provides us the ability to seek this information and, indeed, to have access to it without even seeking it. So FOIA, most folks know as a law that allows you to submit a request to an agency to get information. You get a response weeks, more likely months, perhaps even years later, often with redactions, but you can submit a request and get information. That is a very important tool, but it is not the only tool available under the Freedom of Information Act. In 1996, under what are called the e-FOIA or electronic FOIA amendments, Congress imposed additional duties on agencies to affirmatively disclose information, to proactively post information on their websites without ever receiving a request. And this specifically applies to information of significant public interest. There is, of course, a very long-standing, well-documented, and strong public interest in animal welfare. As I mentioned before, when the Animal Welfare Act was originally enacted in 1966, both Congress and Life magazine got more mail about animal concerns than the Civil Rights Movement and the Vietnam War combined. This interest has been strong and abiding ever since. As a result, the U.S. Department of Agriculture has repeatedly and explicitly acknowledged its legal duty to post information related to the Animal Welfare Act. And there's specifically 3 categories of information that the agency has routinely posted. I'll talk about each: annual reports, inspection reports, and enforcement actions. First, annual reports. Research facility annual reports. Under the Animal Welfare Act, every regulated research facility is required each year to file a report that details the number of animals that it holds, the number of animals it uses for experiments, and importantly, the number of animals who are subjected to pain and distress without relief, and an explanation of why unrelieved pain or distress was deemed necessary, as well as an explanation of any departures from other minimum welfare standards, such as holding animals in the dark for days on end and keeping dogs tied up. For example, Utah State University's most recent annual report documents that the university held 1,368 hamsters, 62 guinea pigs, hundreds of other animals. It further documents that all of those guinea pigs and more than half of those hamsters were subjected to procedures that involved unmitigated pain or distress. The explanation for not relieving these animals' pain is that they were used for antiviral drug experiments, the purpose of which was to identify the minimum dose that would kill about 90% of the animals. And there was a concern that pain relief or even palliative care for the animals might interfere with the operation of the antiviral drugs and potentially alter the outcome of the infections they were given. Every research facility needs to file this report every year, and it's a really important tool for observing whether or not they're complying with the minimum welfare requirements under the Animal Welfare Act, especially given the USDA's failure to do so. The second category are inspection reports. Every time an inspector goes out to a facility under the Animal Welfare Act, they generate an inspection report. This report identifies any violations and details them. It also details the number and the type of animals that the inspector observed. So, for example, USDA Inspector Veterinarian Dr. Melissa Carlson, and I should note, inspectors are sometimes veterinarians, but not always. About half of them are veterinarians. This one, Dr. Melissa Carlson, was a veterinarian. She went out to inspect Mose Zook, one of the many guinea pig breeders in Pennsylvania, and observed 761 guinea pigs and cited him for violating 3 minimum requirements. The USDA cited Mr. Zook for inadequate veterinary care, among other things. This was a repeat violation, meaning that he had very recently been cited for violating this exact same requirement. It was also a direct violation, which is recognized as the most serious type of violation. It is a violation that at the time of the inspection is having a serious or severe adverse effect on the health and well-being of an animal. The inspector observed more than a dozen individual animals suffering without any treatment during the inspection. She saw a black and white guinea pig who was lying on her right side, gasping and kicking her feet. She saw that animal die during the inspection. The USDA inspector saw a tricolored guinea pig who was lying on her left side with her legs spasming, unable to stand. She also saw that animal die during the inspection. She saw another guinea pig with blood around her eye, crusting skin and hair loss. She saw guinea pigs who had safety pins through their ears, Mr. Zook's way of identifying which ones were males. The inspector also saw a number of guinea pigs who were huddled on top of a dead cage mate. All of this is detailed in the inspection report. All of this is important information for the public to be aware of in order, among other things, to get help to these animals when the USDA is failing to do anything besides document the violations. The third category is enforcement records. That is how I'm able to give you examples of how the USDA has failed to enforce the law because they're required to post their enforcement actions. That is why I was able to conduct a comprehensive analysis of recidivism by those who had received warnings. Access to all of this information is critically important, of course, to hold the USDA accountable, but also to get help to the animals the agency is failing. To give you just one example of how this is done, myself, on behalf of PETA, other groups like the Animal Legal Defense Fund, and a growing number of folks are using this information to bring lawsuits not under the Animal Welfare Act because it doesn't have a citizen supervision, but under the Endangered Species Act on behalf of animals held by USDA licensed facilities, arguing that this violates not just the Animal Welfare Act, but also the Endangered Species Act. And this has proved a really helpful tool to rescue dozens of animals who the USDA has left to languish. So having access to this information is really, really important. It is also required by the law, and the USDA has acknowledged that. Nevertheless, on Friday, February 3rd, 2017, just days after Trump was sworn into office, the USDA took all of these records off of its website. Thousands and thousands of records that had been made available for years, that the USDA had repeatedly acknowledged it was required to post online, were gone with very little explanation. Without this information, advocates, scholars, the media, consumers were unable to monitor not only what the USDA was up to under the Animal Welfare Act and whether or not it was doing its job or how poorly it was doing its job, but also unable to figure out which animals needed help and get help to them after the USDA failed them. So that was the first time I personally sued the US Department of Agriculture. I needed access to this information to do my work. And so I joined a coalition of animal protection groups to compel the USDA to release this information. I also worked with a coalition of groups to get Congress to put language in place that would require the USDA to restore access to this information. Thankfully, after months, it was restored. It remains available to this day. And it is absolutely essential that we ensure that this access to information persists, that it is not taken away from us again, that our ability to at least help animals who the USDA is failing remains in place. To wrap up, the Federal Animal Welfare Act was initially enacted out of concern for pets, cats and dogs, who were being rounded up and sold off to laboratories. But it has been expanded over the years and now covers a large category of animals, those in exhibition, the wholesale pet trade, commercial transport, as well as research. But many, many animals are excluded from the Animal Welfare Act's protections, and even those who are given those protections only get bare minimum oversight. And when there are violations, there's not effective enforcement to address those violations. Transparency is absolutely critical to continue to monitor the USDA and hold it accountable for its failings and to be able to step in and help animals. But it's not enough. We need to do more to make good on the promise of the Animal Welfare Act more than half a century after it was enacted. We need to address these enforcement failings once and for all. I have 2 recommendations for things we can do to get at the root cause of this problem and make better on it. I could make a lot more recommendations. I have done so in my scholarship and my advocacy over the years. We could talk about expanding the Animal Welfare Act to cover the many, many animals who are excluded, farmed animals, rats, mice, and birds used for research, cold-blooded animals. There's no reason they shouldn't be given minimal protections. But the truth is, as long as enforcement is as poor as it is, it's not going to mean a whole lot to bring those animals within the ambit of the Animal Welfare Act. So we need to start with a citizen supervision and a new federal agency. As I've mentioned, a citizen supervision is a legal mechanism that allows private parties to go into court to sue to get injunctive relief, not monetary penalties, injunctive relief, help to animals, help to the environment, as the case may be, to supplement government enforcement. This is not a novel idea. This is a well-established component of our legal system. It's particularly prevalent in our federal environmental laws, which were enacted around the same time that the Animal Welfare Act was. It's in the Clean Water Act, it's in the Endangered Species Act, it's in a host of other federal laws. It's critical that we add a citizen supervision to the Animal Welfare Act so that we can get help to animals who are being failed by the U.S. Department of Agriculture. But it's not enough. A citizen supervision is meant to supplement government enforcement. When government enforcement is all but lacking, we cannot expect the private sector to take full responsibility for enforcing the law. It takes tremendous resources to bring just one citizen suit. There can be extensive discovery. It can take years, and it's not fair to put this onus on private individuals and organizations, and they simply don't have the capacity to address the millions of animals who are supposed to be protected by the Animal Welfare Act. So we, second, also need a new independent agency, an animal protection agency, just like we have an environmental protection agency, who has one mandate, protecting animals. Does not have a conflicting mandate of promoting American agriculture, a desire to treat users of animals as customers, but simply protecting animals. The USDA has made abundantly clear that it has no interest in enforcing the Animal Welfare Act. But that's not the only animal law that it's failing to enforce. The USDA is also failing to adequately enforce the Humane Methods of Slaughter Act. Its own Office of Inspector General has also condemned this failing. The USDA is not properly enforcing the 28-hour law, which is supposed to provide minimal protections to animals during transport. Every animal protection law the USDA has been asked to enforce, it has failed to do so. It's past time that we give this responsibility to someone that wants it and is motivated to take it seriously. I recognize that it's difficult merely to pass a federal law, let alone create an entirely new agency. I realize this is not going to happen overnight, but it has to happen eventually, and we have to start pushing for it. In the meantime, there are other things that we can do, and there are things that every one of you can do. One of those, no matter what your profession, no matter what your educational level, is to work to get laws passed in your local community, to go to your city council, your county commissioner, your town council, whatever the case may be, and get them to take steps to make sure that at least animals are protected in your community. There are abundant examples of this happening all over the United States, where local governments are stepping up to protect animals who the USDA has failed, to say, we're not going to allow traveling wild animal exhibits in our community anymore. We don't want to be a part of that. To ban retail sales of cats and dogs. And there are other examples as well. There are lots of resources to support you in this, to help with drafting and lobbying. I would be happy to help you with it through the Animal Law and Policy Institute. You can do it. It's something that's very empowering and that can make a big difference for animals in your community. Lastly, if you do nothing else, please do your homework, educate others, and do not assume that the fact that an entity has an Animal Welfare Act license means anything. It does not mean that animals are being treated well. It doesn't even mean that animals aren't dying due to inadequate veterinary care or other conditions. It's critical that you be aware of this and that you not support these entities. You can educate yourself using the information that I've talked about that's available on the USDA's website. If you're curious about a facility, maybe it's an exhibitor in your community or a dog breeder, you can look them up and look up their records and see if they've been cited for violations, if they're one of the few who've actually had an enforcement action. If that's the case, that is a red flag. And it means that they are among the worst of the worst, because it is extremely rare for the USDA to take any action, including a warning. It is also rare for facilities to be cited because the requirements are so minimal. So it's also important to remember that just because a facility maybe hasn't been cited by the USDA or hasn't faced an enforcement action, that does not mean conditions are okay. That means that the USDA, under the minimal standards of the Animal Welfare Act, has not seen fit to take action. But that is a very different standard than most of us would apply to animals. And you need to take it upon yourself to figure out what's actually going on in a facility, or simply choose not to support them. For the Animal Law Fundamentals series, this is Delcianna Winders.